Hello and welcome to Law Matters. My name is Michael Conroy and I will be your host as we explore various legal topics that impact the lives of many of us or our friends or families on a daily basis. I'm a partner at Hassett George, a full-service law firm with offices in Simsbury and Glastonbury. I've been in practice for 29 years and my practice is concentrated primarily in the area of civil litigation, handling matters such as personal injury and insurance coverage disputes. On this program, we hope to bring you information that is eye-opening and informative regarding many areas of the law that touch many of our lives, but about which there are common misconceptions. Please remember that this program is informational and is not a substitute for legal advice regarding your particular situation. Each individual case is unique, and while we hope to inform and educate you regarding general legal issues, I cannot urge you enough to seek competent legal representation if you are presented with a legal problem. Your rights and financial well-being could depend on it. We welcome your feedback regarding the show. If you have any questions, comments, or suggestions, or if you would like to request topics to be covered on future episodes, please email us at lawmatters@hgesq.com. Today's topic will be Wills and Trusts 101. We hope to provide you with a basic understanding of what is involved in estate planning. We believe that estate planning is something that everyone should do. In addition to deciding what will happen to your assets after you pass away, estate planning also involves sharing with your loved ones your wishes about what kind of care you would like to receive and logistics such as funeral arrangements. My guests today will be Doug Gordon and Rebecca Vicente. Doug joins us from New England Financial Group. Throughout Doug's 30-plus years in the financial services industry, he has developed extensive experience in the areas of investment strategies and retirement planning. His goal is to provide tailored financial services to his clients, and he remains focused on helping them to organize, protect, grow, and preserve their wealth. Doug's commitment to developing and maintaining long-term relationships runs alongside his pursuit of excellence and utilizing the highest ethical standards. He has attained many prestigious industry honors and is a member of the $1 Million Roundtable. This organization is recognized internationally as the standard of excellence in life insurance and financial services business. Thanks for being here, Doug.
Thank you.
Our other guest is attorney Rebecca Vicente. Rebecca and I practice together at the law firm of Hassett & George, where she focuses on estate planning and probate. When developing an estate plan, Rebecca gets to know her clients, assessing their unique needs, challenges, and goals. She enjoys working with clients to determine what will work best for them and their families, ensuring that their loved ones are protected and that their assets transfer smoothly. Rebecca also guides families through the probate process after a loved one has passed away, helping them to prepare probate petitions, estate tax returns, accountings, and financial reports. The probate process can sometimes be complicated and overwhelming, and Rebecca's goal is simply to simplify the process and provide families with the support they need. Doug and Rebecca, thank you for being here.
Thank you for having us.
Now, before we get into wills and trusts, I understand that estate planning involves documents that are used before you pass away. For example, a power of attorney and a living will. Can you tell us about those?
Sure can. And Doug, I'm sure you've seen this situation as well. If you have an asset that's owned in your own name and you become incapacitated, you're going to need some kind of legal authority for a family member to access that asset to help take care of you. I'm sure you have people trying to access brokerage accounts or retirement accounts when there's a need for long-term care services. If you don't have somebody already named to be able to access those assets, you're going to end up having to go to the probate court, which takes time, it's expensive, it's a little embarrassing where you've got to bring a family member into court to establish that they are not competent. Nobody wants any of that to happen. So one of the most important things to make sure that you have, whether you are age 18 or 108, is a financial power of attorney for any period of disability and medical directives, which you touched on as well. Who can make medical decisions for you if you're in a position where you can't? Who is going to be able to get information from your doctors? Who can they speak to about what's going on with you? And for end-of-life care decisions, a living will, which would govern what happens if you have a terminal condition that's likely to lead to your death soon, or you're in a coma, unlikely to come out of it. What kind of care do you want at that point in time?
Now, what happens if you become incapacitated for some reason and you don't have those documents? If you are married, does your spouse automatically have those rights?
Generally not. If you have joint accounts, spouse can access those funds. If you are talking about a medical emergency, doctors will sometimes take information from the immediate family members that are there. But the reason that living wills have become so common now in just regular American life is because of cases years ago where somebody on the young side developed some kind of significant medical illness, and spouse thought that the doctor should do one thing, parents thought that the doctor should do another, and those cases went through the courts for years. The fallback position in this kind of a situation would be somebody would have to file a petition with the probate court to be appointed as conservator and get legal authority to start making either financial or medical decisions at that point.
It's a nightmare.
It's a lot of work for everyone involved. And for medical
costly.
decisions, if it needs to be done quickly, the probate court isn't quick.
Right, and it's costly.
Yep.
Okay. So why should someone have a will? Let's say if someone's married, doesn't everything automatically go to their spouse?
That's also not
True.
Doug, you see this as well.
No, boy.
Talk to us about beneficiary designations a little bit, and then I will catch us up on what can go wrong in other areas.
Oh, absolutely. And beneficiary designation topic it's interesting because it's either overlooked or taken for granted. When you're filling out a beneficiary on a standard investment, such as an IRA, a company-sponsored retirement plan, life insurance, the money at the time of the person's death, will go around probate and directly to the beneficiaries. That's very important because even after the demise of the individual, there still could be bills coming into the home that need to be paid: credit card bills, health care bills, loans such as mortgages, even final expenses. So to get that around probate and through to the beneficiaries quickly is enormous, particularly with life insurance, because the proceeds to the beneficiaries come to them tax-free. So that's one issue that's, when it comes to beneficiaries, that's overlooked. So that's something that you should look into. Double check, make sure that your beneficiaries are up to date. The second one, in regards to beneficiaries, is contingent. I cannot tell you the number of times I'll sit down with someone, go through their beneficiaries and say, okay, God forbid if there's a simultaneous death and there's over 100,000 of them on average per year over the past 20 or 30 years with the advent of the automobile and how people are driving. Think about that, 100,000 simultaneous deaths per year. If you don't have a contingent beneficiary, do you know what happens? The proceeds will go to the estate, and therefore it will now be subject to estate proceeds, as well as potential costs and taxation. It's a disaster. So not only double check your beneficiaries, but make sure you have contingent beneficiaries as well.
And I would presume you need to update those.
Check them every 2 to 3 years, just for nothing less, to give you peace of mind.
Yeah.
Okay.
We've all heard the stories about if someone passes on, they haven't double-checked their beneficiaries, and half the life policy or the whole life policy goes to the ex-spouse.
Or a girlfriend. Right. Or a prior individual that individual wanted to receive the monies. Yes, it could be a real problem. And then you go from probate court to a whole nother court, which becomes just a nightmare.
That's where I come in, and you don't want that.
No,
you don't want that.
No, you don't want that at all.
So Rebecca, Doug was just talking about when someone has the proper beneficiaries on, for instance, a 401k or an IRA, something like that, then the designation of those beneficiaries can help that asset avoid passing through the estate or being subject to probate. What happens if that's not properly done?
So if you don't have your own rules in place, there are statutes that will govern who's going to inherit what you've left behind. And if you're married and you have children, your spouse does not inherit 100% of the probate assets. And that means the assets that have no other way to transfer don't have a beneficiary. Your children are going to inherit a share of those assets. And that share is going to vary depending on whether they're children of both parents or whether the parents have separate children. And in particular, when the children are minors, they could be inheriting a substantial amount of money that they are just not even emotionally mature enough to handle. And if you have a surviving spouse, no children, and parents, your parents are going to get a share of what you would have thought would simply go to the spouse. So there can be additional parties that need to be involved in protecting the rights of the minor children who have a right of inheritance. That adds time and expense. You're not going to have the ability as the surviving spouse to manage those funds and use them as you would want. They are literally the child's funds, and at age 18, they'll be released to the child.
Which brings us to another subtopic that I think is interesting. What's the difference between a will and a trust? Do you need one, the other, or both?
If you have a trust, you will have a will as well. If you have a will, then you've chosen not to put a trust in place. So a will is a document that has to be submitted to the probate court, and your executor needs to be formally appointed before anybody has access to your assets and legal authority to act on your behalf. And a trust is different in that your trust can own assets during your lifetime. Your trust can name a successor trustee, and that person can step in without any authority from any judge and start managing assets as soon as you've passed away. That's one of the differences. The trust does keep your affairs more private. Your will is going to be filed with the probate court and will be a public document that anybody can look at. The inventory that you file, your financial report, all of those documents are readily available to anybody who wants to go looking through. A lot of my clients are very offended to get letters from real estate flippers on a regular basis just as soon as they've opened a probate, and most of the surviving spouses are not looking to sell their house for cash cheap right after losing a spouse. The probate court process also invites family members who might want to lodge a dispute to come on in at any point in time and to do so. The trust, by keeping things private, makes it a little bit harder for somebody who wants to challenge the documents you've put in place to do so, and they would have to initiate an action on their own.
Okay. Now, you mentioned moments ago the possibility of children, for example, who might not be, even if they're over 18, might not be prepared to properly administer a large sum of money that they might suddenly come into. Mm-hmm. Is a trust a good way to take care of that problem?
It is. You can leave assets to your beneficiaries two different ways. You can leave assets outright, meaning they get what they get and they do whatever with it they wish, or you can leave them in some kind of an ongoing trust structure. You can do that under your will if you want the probate court to supervise the administration of that trust until it terminates, or you can do it in what we call a revocable living trust. And you get to decide who's going to be in charge of managing those funds. At some point in time, you might want the child to have some say in how those funds are managed, and they can be what we call a co-trustee. And you can give some direction to whoever's managing the funds as to how much or how little you would like distributed over whatever period of time. It can be fully discretionary. The idea is to choose somebody that shares your money values, understands what you would do for the kids if you were here, and to kind of step into your shoes that way. It provides some protections as well for possible creditors that the children may have, and if we're talking about adult children, what might happen to those funds if they get divorced.
Okay. Now you mentioned that even if you have a will, it would be filed with the probate court, right?
Yes.
Now, but if someone has a comprehensive will that addresses all of their desires, as well as maybe a trust if necessary and appropriate, and they've made all the right beneficiary designations, how streamlined can the process be in probate?
So if the trust has been designated as beneficiary or already owns most of the assets, and if there aren't minor children, because one important thing that the will does is appoint guardians, and a trust can't do that. But if we set those things aside, the only thing that you might have to do with probate if you have a properly funded trust plan is file a particular kind of a tax return. And that would be something that you would file. The probate court charges a fee for their services, regardless of how much or how little you've used the court services. It's a fraction of 1%. And once that fee is paid, that could be all you have to do. It's what we call a tax purposes only estate. So now your trust can be wrapped up in 3 to 6 to 9 months, depending on what it is you're trying to do. Are we fixing up real estate? Are we selling? Filing tax returns, income tax returns would still have to be taken care of. But the average probate court process can take 12 to 18 months. So there can be a significant difference. The probate court process also involves an invitation to creditors to come forward, and there's a period of time where you simply can't move the probate file along because creditors have an opportunity to show up and make sure that they get paid before distributions are made to beneficiaries.
Now, staying with beneficiaries, you mentioned a few earlier, Doug, but what kinds of benefit plans require someone to select a beneficiary?
Well, 401k plans, 403b, or better known as tax-sheltered annuities, simple IRA retirement plans, IRAs, both Roth and traditional, tax-sheltered annuities, and life insurance.
Okay. Now, we touched on this moments ago, but in terms of selecting beneficiaries, and you mentioned contingent beneficiaries, how should people go about that, and what sort of life events should prompt them to revisit that topic?
Well, there's quite a few, but one that comes into mind when you have children, you want to make sure that if you have a minor, a very young child, that if there's a tragedy, you want to make sure, and both parents, as I mentioned, pass away simultaneously, there's no judge in this country that I think is going to give $100,000 to a 3-year-old. You've got to make sure that the beneficiaries are properly set up so that the contingent beneficiaries or secondary beneficiary will be a trust where you have guardians to look over and for the best interest of the children. That's one issue in particular. Also, special needs children. That's very important. We'll make sure that we set up the special needs documents so that that child will receive the appropriate care from the respective state without conflicting with monetary issues.
Okay. So when should people start thinking about estate planning?
So depending on the level of planning that you're doing, at age 18, we have clients who come in, kids who are going off to college. Once the kids turn 18, mom and dad can't just make healthcare decisions for them, can't manage their finances for them. And granted, these are not kids with lots of money, but if they are away at college and they're in an apartment and somebody needs to talk to their credit card company or to a utility company, you need your financial power of attorney in place to do that. And heaven forbid somebody gets sick while they're away at school or even in the home. If they're over the age of 18 and mom and dad want to have access to that health information and be able to make decisions for them, they should have the proper medical directives in place. Further along from that, when you have minor children, should you at least have a will in place that specifies who's going to be their guardian? Yes, that's one of the things that you should do. And when you start accumulating significant assets, that's when you want to make sure that there's a trust for them so that you're not giving a ridiculous amount of money to somebody who doesn't have the financial maturity to manage it at that point in time.
Or have the proceeds be caught up in probate unnecessarily.
Yep. And then much further down the line, we start talking to clients about costs of long-term care and how do we plan around that. There are only 3 ways that can be paid for. You can pay privately, you can have long-term care insurance coverage, or you can qualify for Title 19 or Medicaid. And that's kind of a conversation that's personal to each family as far as what their preference would be and how can we plan in advance to make sure that there may be enough funds available to keep them out of the nursing home for as long as possible while still being safe in whatever living situation they're in.
Getting proper care.
Okay. So we have here an estate's attorney, and we also have a financial advisor. When someone is thinking about the long term and their overall estate plan, who else should they be thinking about adding to their network of advisors?
Well, I think an accountant is a good idea. Also start thinking about who's going to be the executor or executrix of the estate, because they need to know where everything is so that if there's bills to be paid, they come into the picture as well. Setting up a binder, what I call a binder, and having reviewed everything spelled out. Here's policy 1, here's policy 2, here's our retirement accounts, Here's the name of our attorney. Here's the name of our financial advisor. Here's the name of our accountant, because the accountant does have to do the tax filing as well. It's all
Here's
listed
our
out.
bank. Here's
Right.
where our checking and savings are.
All the
Things that
account
you won't
numbers.
see.
Correct. Everything's spelt out. Even if it's just on a one-page, cheat sheet, is wonderful. It helps out quite a bit.
Plus a map to the coffee can buried in the backyard with all the gold.
Yes.
Right by the money tree.
Right, exactly.
The password to the safe where all the documents are locked. Yes.
Sure, that helps. Okay, well, we could spend a lot of time on this topic, going into all the little various subcategories, but is there anything else that you think people should know just about the basics of wills and trusts?
I think it's important, particularly if you're conscientious and you wish to have your final, thoughts be carried out and not become also a burden after something happens to you should you pass away prematurely. I think it's one of the best investments a person can make, even if you're only 21, 25, 27, you're single. You should have a will and maybe even a trust as you've accumulated assets to establish one, whether you have a family or not. It will help out quite a bit and it will give you peace of mind.
Any closing thoughts,
I
Rebecca?
would say, the most important thing is to share as much as you're comfortable with your family ahead of time, so they know who you've chosen. The oldest child isn't always the best person to be managing finances or medical decisions, and the more you can involve your family in the process, make sure they know what you want for your own medical care and they're not guessing. You don't have to share specific financial information with anybody, but you can talk about what the plan is. Makes it a whole lot easier when somebody's grieving and then has to step in and start managing those things.
Sure. All right. Well, thank you both. Appreciate it.
Pleasure.
Fine.
We're out of time for today. We hope you found the show helpful and informative. I think we can all agree that discussing death can be uncomfortable, but you are doing your loved ones a favor by planning ahead. Again, this program is intended for informational purposes and is not a substitute for legal advice regarding your particular situation. Each individual case is unique, and while we hope to inform and educate you regarding general legal issues, I cannot urge you strongly enough to seek competent legal representation if you are presented with a legal problem. Your rights and financial well-being could depend on it. From all of us at Law Matters, thanks for watching, and please tune in next time.
Funding for Simsbury Community Television is provided in part by contributions from viewers like you. Thank you.